So that's the scope. Now let's talk about how to make an offer. There's a particular issue that we've looked at here, and this is the tension again between the need for certainty. What I mean by that is Part 36 offers have huge consequences, especially if you're talking about indemnity costs, or if you're talking about a claimant being hit, a claimant who wins their case ultimately, being hit with all the costs of trial. These things are significant. Therefore, you need to know, when you've got it in your hands, whether or not you're being faced by a Part 36 offer. Equally, though, we shouldn't make the thing so technical that it really is a minefield and a matter of chance whether or not you qualify as a Part 36 offer or not. I certainly subscribe to this view that a formal defect that causes no real uncertainty should not, perhaps I should qualify and say lightly, invalidate an offer. And I get some support from Mr. Justice Underhill in Huntley and Simmons, and then from Lloyd and Reimer in this AFBG case that we looked at a moment ago. Let me put some flesh on this. This was the old rule, that you had to state on the face of your offer that it was intended to have the consequences of Section 1 of Part 36. And this chap here is Judge Behrens, who sits in Leeds as a High Court judge, and I'm proud to say that one of my colleagues in our Leeds chambers managed to argue in front of him that a certain letter did not qualify. Let me read the letter to you, or at least part of it. Capital letters, bold, underlined. Offer made pursuant to Part 36 of the CPR. Dear sirs, we write further to the above, and in one last attempt to settle this matter, we're instructed to put forward the following offer. This offer is made pursuant to Part 36 of the CPR, and on it went. But, my colleague argued, where has the writer said that it's intended to have the consequences of Section 1 of Part 36? And Judge Behrens said, no, you're right, this is not a compliant offer. Now, I have to say, I don't think much of that decision with respect to the judge, should he be watching, or indeed be in our audience tonight. But if you look at 36.5 at page 4 of my handout, you'll see our new wording to deal with this particular point. We say that you must make clear that it is made pursuant to Part 36, which is going back really to a test of, provided you've made it clear, in other words, so that nobody's misled, they understand what they've got in their hands, that we don't think you should have to have this sort of magical incantation of certain words. And so that is the change that we've made there. There's another issue that we've changed under the making of offers. You'll be familiar, perhaps, with the case of C&D, Lord Justice Rick's judgment in 2011. And what happened in that case was there was on the face of it, a Part 36 offer, but it said it was open for 21 days. And there was the debate as to whether or not a time-limited offer, one with a sunset clause, that's my slide, one with a sunset clause, whether or not that is actually a true Part 36 offer. And Lord Justice Ricks ruled as follows, that the 2007 reforms, with its careful code and with its specific rules about when you can withdraw an offer, doesn't appear to allow for a time-limited offer to be made. And therefore, he ruled that if you put in a time limit, if you put this sunset clause in, it doesn't qualify. Now, those who really know the case will know he avoided the results of that reasoning by interpreting open for 21 days as really a further reference to the relevant period and not suggesting it was closed on day 22. But back to Leeds, Judge Behrens, on slightly different wording, said, well, first of all, I'm bound by C&D. A time-limited offer doesn't qualify. And this is slightly different wording. I'm going to distinguish C&D. Again, this is not a Part 36 offer. Now, for my money, there's a problem with this. It seems to be an elephant trap. But I then stood back and thought, well, why do we want this prohibition anyway? What purpose does it serve? As the rules currently stand, you can write your Part 36 letter, and 21 days later, you can diarise it now if you want, you can write your withdrawal, and there's no problem with that. Arguably, and it's not been tested in a case as far as I know, you could write both letters on the same day if you like. This is my Part 36 offer, and this is my 21 days notice of withdrawal at the end of the relevant period. And I couldn't really see what purpose it served in preventing you, if you really want to do this, from withdrawing it or giving the time limit right at the time you make the offer. Therefore, we've got a new rule. If you look at 36.9, which is all about the withdrawal of offers, page 6, paragraph 4 of the rule, 4A is not different, but 4B tells you that after expiry of the relevant period, so you couldn't obviously require the thing to end earlier than the 21 days, but after the expiry of the relevant period, the offer may be automatically withdrawn in accordance with its terms. And that is intended to be the C and D reversal. I was emboldened in this approach by speaking to those involved with the 2007 reforms, and I asked them, because Ricks thought that their reforms had effectively changed this position, I asked them whether that was the plan, and no, it was not. This was an entirely unintended consequence of their drafting, and they supported the idea that we should get rid of it. Now, that doesn't mean that it's necessarily a smart thing to do, of course. You might say, and it's been argued against me when people heard that this is what we were planning, that this will allow, particularly maybe defendant insurers, to put unacceptable pressure upon particularly individual personal claimants. It's true, I'm sure, that this change will be exploited. I'm sure people will use it tactically. Everything you do about Part 36 surely is tactical. And that's the whole purpose of it, isn't it? And I'm sure people will use it as a weapon. But let's not run away with the idea that it's that powerful a weapon, because this is the numbering of where you will now find it, but the principle's not any different under our new rules. If, of course, the offer has been withdrawn, then after trial, it will not be given Part 36 consequences. The fact that for 21 days last May, he could have taken this money might help you a little bit in your Part 44 general cost argument, but you're not going to get your bells and whistles under Part 36. So I think the main thing we've done is at least avoided a ground upon which the thing can be found to be invalid.